Hello everyone, my name is Muskaan and today we're going to be looking at 9 important cases under contracts law. So basically these cases should be on your fingertips while studying contracts and they'll be very useful to you in your exams. Alright, so the first case we'll look at is Hyde v. Wrench. This was a UK case in the year 1840. So it was a single bench judgment and it deals with counter offer. It deals with the question of whether once a counter offer has been made, would the previous offer still be valid? So the terms that you have to remember are proposal, which is an alternate term for offer, and acceptance. Now we know what the proposal is. Anything that you promise to do or not to do to another party with the intention of getting their assent is a proposal. And what is acceptance? It's basically saying yes to that offer, to that proposal. So the acceptance under section 7 must be absolute and unqualified. That means it has to be a yes and nothing else. If you change the terms of whatever they've proposed, that becomes a counter offer or a counter proposal. We're going to see that in this case. So let's look at the facts of this case. Wrench, who is the defendant in this case, made an offer. He had a property and he made an offer to Hyde that he would sell his property to Hyde for $1,200. Pounds, actually. 1,200 pounds. And Hyde refused this first offer. Wrench went back to Hyde and made a second offer saying that he will sell his property to Hyde for £1,000. Now Hyde took this and he at this point he also said that he will not go any lower than £1,000. Hyde then said, I will buy your property, but only if you sell it to me for £950. So here what has happened is he has rejected Wrench's offer of £1,000 and he has made a counter offer. He has made his own proposal where he's saying, you give me the property for £950. Now, Wrench has already said that he will not go lower than 1,000. So he has refused this £950 and he started looking at other buyers. So Hyde wrote back to Wrench and he was like, all right, fine. You sell it to me. I'll buy it for £1,000. I'll give you the £1,000 right now. You give me your property. But by this time, Wrench had already moved on with other people he wanted to sell it to. So he refused to sell it back to Hyde for that £1,000. So Hyde went to the court and he approached the court for specific performance of the contract. What did he want? He wanted Wrench to give him the property and he will pay Wrench that £1,000. Now the question here is whether the original offer was still valid and whether the defendant was bound to perform it. So in order to figure out whether the original offer, the offer for £1,000 was still valid after Hyde had already made the counter offer, you'll have to also look at whether there existed a valid contract between the two. And if there was a valid contract, then was there a breach of contract that he could ask for specific performance? Now the thing is, a contract is valid only when the acceptance is absolute and unqualified and when the acceptance is communicated. So this is given under section 7 of the Act. So in this situation, if the changes are made to an offer, then it becomes a counter offer. A counter offer kills the previous offer. So the initial offer actually becomes invalid. Once you have made your counter offer, what you are doing is rejecting the initial offer made by that person and proposing your own offer. So then it becomes then the other person can either reject or accept your counter offer. So in this situation, when Hyde went back to him and said, I'll buy your property for £950 instead of 1,000, that became a counter offer, and Wrench rejected that offer. That means there was the original offer. There was no actual valid contract that existed between them. After that, when Hyde went back to Wrench and said, okay, fine, I'll buy your property for 1,000, that is now a new offer that he is making. You cannot consider it as a continuation of the old offer because the old offer has already been rejected. So in this case, the original offer was also not valid and there did not exist any valid contract between them. So that is what the judgment held. There was no valid contract between the parties. There was no breach as the original offer was not valid and the new offer had not been accepted. And therefore, the plaintiff's claims, Hyde's claims, were dismissed. So the next case we're going to look at is Dickinson versus Dodds, and the judgment was given in the year 1876. This was a three-judge bench, and the main question in this case was, is a promise to keep an offer open till a specific time binding on the offerer? So in any case where, say I make an offer to you and I say I will give you 2 days to think about it and you get back to me. Now within those 2 days, if I go ahead and make the same contract with somebody else, even before you had the chance to accept or reject it, would that be a breach on my part? That is the important question here. So again, the important terms here was the proposal and revocation of proposal, which is given under section 5 and section 6. What is revocation? Revocation means to take back your offer. Generally speaking, revocation can only be done before the other party has communicated their acceptance to you. So let's look at the facts of the case now. Okay, so on one Wednesday, Dodds offered to sell his property to Dickinson. And at the same time, he also said, I'm going to leave this offer open until Friday. So that means Dickinson has till Friday to either accept or reject his offer. And it was supposed to be Friday morning, 9 a.m. On Thursday, Dickinson decided that he was ready to buy the property of Dodds. And he thought that since he has till Friday morning, he will let Dickinson know of his acceptance either by Thursday night or by Friday morning. Then, Thursday evening, he heard from his own agent that Dodds was already talking to a third party and he was getting ready to sell his property to that third party. So immediately, he wrote a letter that said that he was ready to accept Dodds' offer, and he sent it to Dodds through someone else. Now, on Friday, what happened was Dodds received the letter in the morning. However, by that time, he sold it to the third party. Later, he met Dickinson that day and he told Dickinson that it was too late for him to accept the offer. So then Dickinson approached the court for specific performance. He argued that he had till Friday morning to accept the offer, and he had sent the letter communicating the acceptance already on Thursday evening. Even if it reached Dodds later on Friday morning, the fact of the matter was that he had already communicated his acceptance, and he said that he had till Friday morning to either accept or reject it. So Dodds cannot have sold the party to a third party by that time, and he should have waited until Friday morning for Dickinson's acceptance. Now, the issues that were brought up in this case was whether the promise to keep the offer open was binding. Was it binding on Dodds that when he made the promise that he would leave the offer open till Friday morning, would that be a binding promise? And whether Dodds could revoke the offer and sell to a third party. When we talk about revoking the offer, all we mean is that he no longer wishes to sell the property to him, and he already has an intention to sell the property to someone else or to not sell the property to him. So this is the analysis that the court made. One, an offer does not result in an agreement. Just because I have said something, there is no binding agreement yet. So Dodds telling Dickinson that offering to sell his property to Dickinson and telling him that he will keep it open till Friday was simply an offer. It was not an agreement. Till now, Dickinson had not accepted or refused the offer. Therefore, an offer can be revoked before it is accepted. So obviously, if Dickinson had accepted the offer well within time, and then Dodds said no need and went and sold it to someone else, then it might have become an issue. But in this particular instance, it was not an issue because Dickinson had never accepted the offer. So there has to be a meeting of the minds. This is what the court had held. There has to be a meeting of the minds when making a contract, as in both parties need to agree to the same thing. In this situation, Dodds changed his mind and decided he wants to sell the property to a third party. Therefore, there was no meeting of the minds. So what was the judgment? The initial communication by Dodds to Dickinson was only a proposal and it was not a binding agreement. Or moreover, his promise to keep the offer open was also not binding. Why? Because there was no consideration to that, right? Like there was no, when you talk about reserving something or keeping something open, you need to put in some consideration for that. Say you are applying to colleges and you have passed the test, but you still want to apply to more colleges. What would you do to save your seat? You pay a specific amount to save your seat, right? If you didn't pay that amount, even if you had gotten in, the college has absolutely no obligation, the school has no obligation to save that seat for you unless you have paid them some consideration. Similarly, here, there was no consideration as yet given by Dickinson, from Dickinson to Dodds, right? So in this case, there was no binding agreement, or the offer that he had made was not binding. And secondly, there need not be an express withdrawal or revocation of an offer. Dickinson's agent had already informed him that Dodd's mind had changed and he was going to sell it to a third party. That already means the offer has been revoked. So at that time, if he has made an agreement, it no longer is an agreement because now there is no longer an offer. So his claims were dismissed. Now let's look at the third case. This is Kedarnath versus Gori Muhammad, and this was a Calcutta High Court case in the year 1886. It was a three-judge bench, and this talked about a promise without consideration and whether or not a promise without consideration is enforceable. So we have to look at the meaning of consideration, which is a quid pro quo. It's when someone promises to do something or to abstain from doing something, either in the past, present, or future, in return for a promise, right? And the act specifically states that a agreement without a consideration is not a valid contract or a valid agreement. However, Section 25 of the Act also says that there are certain exceptions to consideration. Let's look at the facts of the case. So, Kedarnath was a municipal commissioner and he was the trustee of the Howrah Town Hall Fund. Okay, so he was the trustee of one of the trusts there. He entered into a contract with some construction contractors to build a town hall for this fund, right? This was when we talk about trusts, it's basically a charitable cause. Now, they had a list of subscribers. This trust had a list of subscribers, and they all had made a promise to pay some amount of money to the trust in order for the trust to get enough funds for the construction of this town hall. Now, one of the subscribers, Gori Muhammad, he later refused to pay his share. It was, I think, 100 rupees or 300 rupees, something like that. And when they went to court to enforce his payment, he made two arguments. The first argument was that he was a subscriber of a charitable cause. He was not giving any consideration for the money that he had promised to them. And because there was no consideration, that means his promise is not enforceable in a court of law, as there is no enforceable agreement between them. Secondly, he also said that he was not literate and he had not understood what he had subscribed for when he had promised to pay that money. So the main issue in this case was whether the promise made by the defendant was enforceable or not. Now, generally speaking, under the Contract Act, a promise without a consideration is not enforceable. However, the fourth exception under Section 25 says that it does become enforceable if the promisee relies on the promise to their detriment. This means that if person A promises something to person B and there is no consideration being paid here, so it's not a binding promise. However, relying on the promise made by person B, person A, person B does something that if person A did not follow through with his promise, it would cause the detriment of person B. So in this situation, the subscribers were aware of the purpose of their subscription. when they had made the subscription, when they had agreed to give or promised to pay some money to the trust, they knew that the trust had entered into a contract with the contractors, the construction workers. They knew that the money that they were paying would be used for the construction of the town hall. So, technically, that construction, the town hall's construction, becomes their consideration. It is no longer simply a mere promise, because it would be, if they do not pay the money, it would cause the detriment to that contract between the Kedarnath and the construction company, and they would not be getting the town hall. Therefore, the court held that Gauri Muhammad was liable to follow through the promise he had made. Our next case is Harvey versus Facey. This happened in the year 1893, and it was a 5-judge bench. That means it was the UK Supreme Court bench, or the Queen's Court at the time. The question was, can a quotation be considered as an offer? Can somebody just quoting a price of a product be considered as an offer? So the important terms here is the definition of offer, which is what proposal means under section 2A. What is the meaning of acceptance, which is when a proposal is assented to, and the new term invitation to offer. So let's look at the facts. First, Harvey wrote to Facey saying, will you sell us bumper hall pen? What is the lowest price that you will sell it for? So Harvey is asking Facey to sell Facey's property to Harvey, which is a hall, and Harvey is saying, give me the lowest price that you will sell it for. Now Facey responds to this. They were talking through telegraph, right? Facey responds to this saying, the lowest price for the hall is £900. Now be very clear about what Facey says. He does not say, yes, I will sell you the hall. All he answers is the second question. He says, the lowest price I will take for the hall is £900. Harvey then says, okay, we will buy the property. I will buy the property for £900. Give me the title deeds. I'll send you the money. Facey then does not respond, and later when asked again, he refuses to sell his property to Harvey. So Harvey approaches the court. He wants specific performance of the contract. However, the lower court dismisses the case. Harvey then goes to the appeals court, and then the case finally reaches the Supreme Court. So the main question here is whether there was a valid contract between Harvey and Facey. In order for there to be a valid contract, was there a valid offer and a valid acceptance? So the thing here is, an invitation to offer is not an offer, but invites offers which can then be rejected. Now, Facey never said, I will sell you the property for 900. He said, the lowest price for the property is 900. That was a quotation of the price. And this is what contract law terms as an invitation to offer. So say you walk into a store, you go to those street side stores, right? And you say, and you see it written over there, $100. Now you can go and start bargaining, and it is on the shopkeeper to decide whether or not he is going to sell it for $100. He might say, this is an old sign, you pay me 150 and I'll sell it. That becomes an offer. But just the price saying 100 does not mean an offer. It is an invitation to offer. It's like also what happens in auction houses. They start with the lowest bid, and then it keeps rising, and they only sell it to the highest bidder, right? So the 100 is the minimum amount of money they will take for it. But that does not mean it is a final offer. It was only an invitation to offer. So if what happened here was, the quotation that Facey gave was an invitation to offer. Harvey saying, I will buy it for 900 was the offer. And Facey rejected that offer. Therefore, there was no actually valid offer and acceptance. because an offer must show an intention by the offerer to be bound by it. Facey simply saying that the lowest price is 900 does not mean he's willing to be bound by that price of 900. So the court held there was no valid offer and the quotation was just an invitation to offer, and therefore the case was dismissed. Okay, so the next case we have is Carlyle versus Carbolic Smokeballs Company, decided at the end of 1892. This was a three-judge bench, and the major question asked in this case was whether an advertisement can be taken as a promise and whether it can lead to a binding contract. Important to know are all the basic terms of a contract. What is proposal? What is acceptance? What is consideration? Let's look at the facts of the case. Carbolic Smokeball Company was a company that made what they call the carbolic smoke balls. They said that these smoke balls would prevent colds and it would prevent influenza. They put out this advertisement in a newspaper where a reward was offered to anyone who caught influenza while using the product. They said this product is going to make sure that while you are using it, you will not catch a cold or you will not catch the flu. If you use it thrice daily for 2 weeks, they said you have to use it in this way and you will not catch the flu. If you do catch the flu while you use the products, we will give you a reward. We will give you a compensation. And further, they also mentioned the fact that they had deposited money in a bank to show that sincerity, that we have deposited this money in a bank. If you catch influenza while using our product, we will give you this money. So Carlyle, she went ahead and bought a smoke ball. Okay, she bought it, she used it, and she claimed that she had used it exactly as according to the advertisement. However, after a week of using the smoke ball, she caught the flu. So she then wrote to the company asking for that compensation. She said, you had guaranteed that I will not get it. I got it. You also said that you will offer a compensation for if someone catches the flu. I want that compensation. However, the company refused. They said there was actually no contract. That was just an advertisement. So we don't have to pay you at all. And furthermore, the company also pointed out, how do we know that you have used it properly? Maybe you just bought it, you did not use it properly, and you got the flu, and now you want money from us. So they approached the court for enforcement of the contract. So now the question was whether there was a binding contract between the parties, whether the plaintiff had communicated her acceptance of the offer, and whether there was any consideration provided by her. So the main question here we're going to try and answer was that whether or not there was a binding contract between the parties. The other two are secondary to that. If there is a binding contract, how to figure out this a binding contract? What about the communication of the acceptance? Because there was no communication until she wrote to them and said, your thing did not work. Should she have first written to them and said, I have bought it, I'm going to use it as directed, and I'm accepting your offer? Was there any need for things like that? So we're going to see what the court said. First, the court said that this was a unilateral contract. And they said that the language used in the advertisement bound the company to their promise. Normally, if a company simply says, oh, you definitely won't catch the flu while using this, if you do, we'll pay you your money back. Those are usually marketing tactics used by companies, and they're usually not binding on them. It's just a way to get people to buy their products. However, in this particular case, the company also, as a show of their sincerity, said that we are depositing money in a bank, and they showed proof of that, and they said this is the money we will pay you. So now that means there was a continuing offer. They had made this offer to all their consumers, and they had said if and when it does not work, you can come to us and take that compensation. So because it was a continuing offer to all their consumers, there was also no required notice of acceptance prior to the asking for compensation. So the judgment said that there was a valid and binding contract between the parties, and the consideration in this case was the fact the plaintiff had paid to purchase that smoke ball, and she had used the smoke ball exactly as directed. Therefore, the company was liable to pay her the reward or the compensation that they had promised. Now, our sixth case, Mohri Bibi versus Dharmodas Ghosh. This was a 1903 case, and it was decided by a 5-judge bench again. And the question was, is a contract with a minor valid? So this case specifically deals with minors agreements or minors contracts. And what is important to know here is the competency of contracts. Now, what are the essential elements of a contract given under section 10? One of the essential elements is that the parties involved must be competent to contract. What is competent to contract is given under section 11, where it says nobody who is of unsound mind or who is not a major is competent to contract. So minors are not competent to contract. So here are the facts of the case. Dharmodas Ghosh was a minor and his mother was his legal guardian. Now he was the sole owner of some immovable property. He then made a deal with Kedarnath. He asked for mortgage deed on his immovable property. Now Kedarnath was the agent of Brahmodatt, and Brahmodatt was a moneylender. So he may not have directly made the contract with Brahmodatt, but he did make the contract with Kedarnath, who was authorized to act on Brahmodatt's behalf. Now, Kedarnath was the one who was contracting with him, and it was found out that Kedarnath already knew that he was a minor. Moreover, right after this contract was made, when she found out, when Dharmadas's mother found out, she went to Brahmodatt and she informed him of her son's minority, saying that the contract that your agent has made with my son cannot be valid because at the time of making the contract, my son is a minor. However, these guys took no notice of that and they went ahead with the contract. And they paid the money to him on the property. So remember, they both knew about the minority of Dharmodas Ghosh. Afterwards, when they went back to them asking for enforcement of the contract, they went ahead, approached the court, and they said, we want you to void the contract on the basis that when it was entered into, Dharmodas Ghosh was a minor. They argued that Dharmodas had been dishonest about his age when entering the contract at the time of entering into the contract. So let's look at the questions. The first issue is whether the contract was void or not. And secondly, whether the defendant was liable to return the loan amount, whether Dharmodas Ghosh had to return the loan amount that he had taken on the property back to them. So what happens in a mortgage? He had taken a loan and the property had gone to them. Now they wanted their property back and they refused to pay the money back to them, saying that the contract was void. They can't ask for the money also. So the court, while it was discussing the case, pointed out that under Section 11 of the Indian Contract Act, it clearly states that a minor is not competent to contract. And any contract that is entered into with a minor is void ab initio. That means it's void from the start. It's not a voidable contract. It is void ab initio. That means it will be treated as if the contract never existed. Therefore, they held that the contract was void, completely void, and because it was so void, the money that they had paid to Dharmodas Ghosh, they couldn't even ask for it back because that was money they had given to him, but it was not enforceable at all. So they can't get the money back and they have to return the property to Dharmodas Ghosh because they knew he was a minor, and even if they didn't, it would have been their duty to ensure that he was of major age before entering into a contract with him. Our next case is Powell versus Lee. This was a 1908 UK case. And the question was about valid acceptance. It was about how an acceptance can be made valid. Now remember, section 7 says that an acceptance must be absolute and unqualified. Now in this case, the plaintiff, Powell, he applied as headmaster of a school. And one of the managers that he had sent his application to referred his application to the appointing authority, to the board of members. So this board, they actually made an initial resolution to appoint Powell. They had a meeting together, and in that meeting they decided we're going to appoint Powell. Now, one of the members in this board went to Powell without any authorization because this initial internal resolution had not been made public and they had not made any plans yet to communicate this to Powell. So one of the members went to Powell separately and they told him, yes, there has been a resolution that we will appoint you. Later on, the members had another meeting where they changed their mind and decided to offer the position to somebody else. So they went ahead and rejected Powell. However, Powell had already learned about the fact that he had been initially accepted. So he took that as the acceptance and he went ahead and filed a suit for breach of contract against all the members in this, one of the members being Lee. Now, the first question is, was there an actual breach of contract? And to decide whether there was an actual breach of contract, you first have to look at whether there was an actual contract. Was there an actual contract? How do you decide that? Whether there was a valid acceptance to the contract. Because without an acceptance, there cannot be a valid contract. So, the court analyzed the case, the facts of the case, and they said that there was no formal or authorized communication of acceptance to Powell. Once acceptance has been made to the other party, that is when the contract is made. But if there has been no authorized or formal communication of that, then it cannot have been said to be communication. The job opening in and of itself was an invitation to offer. Powell's application to the job was his offer. Now it was up to the board members to decide whether or not to accept his application. And they ultimately decided to reject his application. Even if they had initially decided to accept it, but they had not communicated that outside, and one of the members decided to go and communicate it himself, that does not mean that there was an actual communication, because the final and official communication to Powell was that of rejection. Therefore, the court held that there was no valid contract between the parties as there had been no valid acceptance of Powell's offer, and therefore there was no breach as there was no contract. Our eighth case, I'm sure many of you have already heard of it, Balfour versus Balfour. This was a 1990 UK case by a 3-judge bench, and the question here was whether the contract between the parties was enforceable in court, because the question was whether they intended to enter into a legal enforceable relationship. So that here they mainly talk about what is a legal relationship, what is a contractual relationship, and the case holds that there must be an intention that the agreement should have legal consequences, otherwise it is not a valid contract. If you just make a promise with someone but neither of you intend for it to have legal consequences in the event of its breach, then it will not be considered as a valid contract. Let's look at the facts of the case. There was a husband and wife. They were from Ceylon, which was Sri Lanka at the time. They went to England for a vacation. During that time, the wife fell ill. However, the husband had to return back to Ceylon, Sri Lanka for his work. So she stayed back in in England. The husband then told her, since you are going to be in England while I am going back to Sri Lanka, I will pay you a monthly allowance of £30 for your expenses and your living in England. Afterwards, they spent a few years living apart and their marriage ended up deteriorating. So they finally ended up divorcing. The wife filed a case for divorce. She got alimony also. After the divorce, the husband stopped paying this £30 monthly allowance that he had promised at this time. So the wife went to court and she brought an action for non-payment of this allowance, saying that she wanted this allowance to be paid. Now, the question was whether there was an intention to enter into a legal agreement and whether the agreement between the wife and the husband was enforceable. So the court here states that an agreement between a married couple is merely domestic in nature and there was no intention to create a legal relationship. When the husband agreed to pay 30 pounds allowance to the wife for however long she was in England, he was saying that why? Because at that time she was his wife. He felt he owed that duty to her because of their relationship, and so he was paying her that money. But this is just a domestic arrangement. After the husband and wife got divorced, and he is already paying her maintenance for alimony and all that, then he does not feel the need to pay her that 30 pounds allowance monthly because they're no longer husband and wife. So the court also pointed out that a court cannot go and interfere into every domestic arrangement and try and enforce them because that would create a lot of burden on the court, right? So the court decided that there was no legally enforceable contract between the parties. Once the marriage had gotten over, once it deteriorated, once they had divorced, then there was no liability on husband to pay the allowance. Now our final case is a very interesting one. It's called Donahue versus Stevenson, or the snail case, or the ginger beer case. The question in this case was, can compensation be claimed even without the existence of a contractual relationship? Now, in the previous case of Balfour versus Balfour, we saw that unless and until the parties have an intention to enter into a legal relationship with consequences, the contract will not be enforceable. But in this case, they specifically deal with if the two parties involved do not have even a contractual relationship, they have not directly entered into contract with each other, can compensation still be claimed by one party to another? So this was the case that brought out the changes, it completely changed the legal structure. It brought out the concepts of duty of care, brought out the concept of tort, where they talked about torts. And in this case, it was specifically tort of negligence. And they came up with one more principle called the neighbor principle, which states that if there is a foreseeable certainty, like if you can foresee that the actions of one person will harm another person, then you can take then the other person who has been harmed can take compensation from the first person. So in this case, there was a small cafe on the street which supplied their ginger beer from a particular ginger beer manufacturer. This manufacturer would make and seal the ginger beer and give the bottles to the cafe, and the cafe would sell it to its customers. Now, Donahue and her friend went to the cafe one day, and Donahue bought a ginger beer for Donahue. Donahue's friend bought a ginger beer and gave it to Donahue. Now you can see that there is no direct contractual relationship between these two, right? Donahue's friend is the one who paid for the ginger beer, and the cafe has supplied the ginger beer from the manufacturer. Now what happened was she drank the bottle, and after drinking more than half the bottle, she realized that there was a decaying snail inside the glass bottle which had not been seen earlier. So the question was, what happened was she filed a case against the manufacturer asking them to pay her compensation. Why? Because they are the ones who had manufactured and sealed the bottles. So if a snail had entered into a bottle, it was their fault and not the cafe's fault or her friend's fault. So she wanted compensation from the supplier. But there was no contractual relationship between them. So in this case, the question was whether the manufacturer owed Donahue a duty of care. Should the manufacturer be liable for the harm he had caused to Donahue? And the other question was whether an action of negligence would be applicable even though there was no contract between the plaintiff and the manufacturer. So the court brought forth the neighbor principle, like I said, where if there is a relationship between two people where it is reasonably foreseeable that the actions of one person will harm the other person, then they can take an action for negligence and they can claim compensation. So they also brought about the concept of tort of negligence and the concept of duty of care. The court held the manufacturer had a duty of care to all its end consumers. Whoever was drinking the ginger beer, the manufacturer had a duty to them. So there was no contractual duty as such, but there was a general duty to ensure the integrity of the product. They were the ones who should have checked before sealing the bottle to make sure that their goods were of good quality and would not harm other people. So, we're done with all the 9 cases. This was a very long video, and I hope these cases will help you in understanding contracts a little better and in writing your exams. Thank you so much for watching. Please like and subscribe, and have a great day.